Today, we're going to dive into the incredibly complex and often confusing maze of India's criminal justice system. We're going to break down what you can actually do when you believe you've been wrongly accused and need to challenge your case. So let's get right into it.
So, let's just imagine it. You've been falsely implicated in a criminal case. It's a terrifying thought, right? But the law does give you ways to fight back. The absolute key, though, is knowing which legal tools you use and, just as importantly, when to use it. Because as you're about to see, timing is literally everything.
All right, so every criminal case in India, no matter how big or small, has the same starting point. And that starting line is the filing of something called an FIR. The First Information Report, or FIR, is pretty much what it sounds like. It's the very first official piece of paper that kicks the entire machinery of a criminal investigation into gear. As soon as this document is logged, the clock officially starts ticking on your case.
Now, as soon as an FIR is filed with your name on it, your most powerful and immediate option is to try and get it quashed. Quashing basically means asking a higher court to just cancel the FIR, to tear it up and stop the investigation dead in its tracks before it can even really get started.
So how do you do it? To get an FIR quashed, you have to go to the High Court, and you've got two main legal roads you can take. First, there's Section 482 of the Criminal Procedure Code. This is where you ask the High Court to use its inherent powers to stop the law from being misused. The second path is filing a writ petition under Article 226 of the Constitution, which is a really powerful tool that uses the court's special constitutional authority. But here's the thing. The police aren't just sitting still while all this is happening. What if they finish their investigation before you can get that FIR quashed? Well, this is where the game changes, and things get a lot more complicated, because their investigation ends with a brand new document, the charge sheet. Think of the charge sheet as the police's final report card on the case. They file it with the court, and it lays out every piece of evidence they've collected and officially points the finger at the people they believe should be put on trial. Once this is filed, the investigation phase is over, and the court phase is about to begin. And this is a huge strategic shift. Once that FIR has ripened, as they say, into a charge sheet, a lot of high courts get a bit hesitant to step in. Their logic is kind of like, well, hold on, there's another option now. A new path has opened up. You can now ask the trial court for a discharge. And because that other remedy now exists, the high court might just tell you to go there first. So now you're at a critical fork in the road. It's a major strategic decision. Do you keep trying to get the case quashed up in the high court, or do you change tactics and argue for a discharge down in the trial court? The answer really boils down to one very important difference between the two. Now, take a look at this table. The real game changer is that last row. This is the whole thing, right here. When you ask a trial court for a discharge, the judge can pretty much only look at the evidence the police put inside their charge sheet. But when you ask the high court to quash the case, it has the power to look at evidence outside the charge sheet. So if you've got that crucial piece of evidence proving your innocence, but the police didn't include it, quashing might be your only shot to get a judge to see it early on.
Okay, all of this has been leading up to one single, absolutely critical moment. It is a legal point of no return after which one of your most powerful options just disappears. That moment is called cognizance. So what in the world is cognizance? You can think of it as the official starting pistol for the court case. It's that specific moment when a magistrate looks at the police charge sheet, really considers it, and says, yep, it looks like there's a case here. Then they officially start the court proceedings against you by issuing a summons. This timeline just lays it all out perfectly. Right when the FIR is filed, your legal toolkit is full. You have every option. After the charge sheet is filed, things get a little tougher. The path narrows. But the second that magistrate takes cognizance, a massive door slams shut. That incredibly powerful option to file a writ petition under Article 226 to get the case quashed, it's just gone. It vanishes as a remedy. So what if that door closes on you? Are you just out of luck? Well, no, not completely. But your legal playbook for challenging the whole case at a higher level, it definitely shrinks. Let's look at what you have left. So, your toolkit has changed. That heavy hitter Article 226 is now off the table for quashing. But you're not totally out of options. You can still go to the High Court, but now you have to use its inherent powers under Section 482 of the CrPC, or its supervisory powers under Article 227 of the Constitution. The fight is not over, but your avenues to fight it have become much more specific.
So as you can see, the system has all these different checks and balances built into it, different off-ramps you can try to take, from quashing an FIR all the way to seeking a discharge. But the way your options shrink over time, especially after that critical moment of cognizance, it really brings up a big question. Does this complicated system actually provide clarity, or does it end up creating a confusing, high-stakes race against the clock for someone who might just be wrongly accused? That's definitely something to think about.